What are the consequences of lying to USCIS or Border Patrol? During an immigration consultation, what questions do you ask?
If you have a big criminal history, immigration has the ability to put you in front of a judge and then take you out. And then you're outside of the United States while your visa is still processed.
If two people get married, if there's a U.S. citizen who marries an immigrant, how long will it take that immigrant to get a green card? It's not just the immigrant's criminal history. The U.S. citizen's criminal history is very important too.
Exactly.
So I want to talk about immigration, talk about different things, but let's start it off with what is your approach to an immigration case?
That's a good question. I think it really depends. It depends on the case. Different cases kind of take a different approach. For the most part, with every immigration case, I think the first step is to figure out their history, their immigration history, what they have, if they were ever caught. And if they were caught, what did they sign, if they signed anything?
Right.
That's always the first one, especially because some people come in, they know they were caught. They know that they were detained at some moment in time. But to them, they were maybe let out within 30 minutes of being caught. And then they take that as they were just let out. Like they have no consequences from that one time that they were detained. And that's not the case. There's always something there. And it's always important to find that out first to see what the route is, which one to take.
So I hear that immigration is very individualized. It's a case-by-case basis. What does that mean?
It ultimately means that everybody's situation is different. Although the process might be the same, there's finite details that change it. You know, one person can have 2 entries rather than the one, and their process fairly could be the same. But that one different or that one additional entry can change it completely. There might be additional steps that they require that the other person doesn't. It could be something as simple as that. It could be as simple as if it's a family petition, their spouse are citizens, while theirs are residents. Same concept, same process. But that small detail of one being a citizen changes it a lot.
So if a U.S. citizen gets married, how important is that U.S. citizen's criminal background?
It's very important. It's very important because certain crimes disqualify them from ever being able to petition somebody. Take, for example, let's say, if we reach out to extremes, let's say like a murder charge or child molestation or something around those lines, those automatically disqualify the petitioner from ever being able to petition anybody, from whether it be spouse, kids, parents. Serious crimes or of that sort disqualify the citizen.
So it's not just the immigrant's criminal history. The U.S. citizen's criminal history is very important too.
Exactly.
Okay.
And then that's also something to look into. Sometimes the citizen, and then I guess the other thing is, how did they become citizens? Were they born here? Or did they adjust through some other, through a different family member?
Right.
How they derived it also affects the case.
How do we find out the background on an immigrant?
The background on an immigrant, it could be done, it's their background checks. But with immigration, they're called FOIAs. So it's Freedom of Information Acts. And there are different agencies that you request them for, because different agencies have different information. Our office, we do 4, which are the 4 major agencies. It's FBI, USCIS, US Visit, and CBP. The FBI one is the quickest one and the simplest one out of all of them. Probably get results in about 2 to 3 weeks. And that one shows anytime you were fingerprinted, whether it be a criminal or an immigration matter, it'll come up. The next one is CBP, which is Border Patrol. So when somebody has definitely been caught, it's definitely important to get down because they're going to have all the information with time, date, names used. Sometimes people come in and use a different name, give different information. That one's definitely going to have it. And then the remaining 2, which is USCIS, that's for the most part if a process has been started for them beforehand. Maybe they have a family or their father started a petition years ago and they just don't have an idea of what happened to it. That one's going to give out that information. The US Visit, it's still very much important, but it definitely falls on the latter of them. Because US Visit will pretty much give us all the information when somebody's been fingerprinted, very similar to the FBI and CBP, but it's always better to just do a model, cross your T's and dot your I's.
So sometimes we get clients into the office and they may not even know their background, right? They think that they got caught, but then we run their CBP and they haven't been caught, or they say that they've never been caught and we run it and we see that they have. So why is it? Why is it that some people don't even know what their background is?
I think some people just overlook it. They see that they got detained for about 5, like I said, 5, maybe even less. Sometimes they say they get caught and then they just turn them right back around. They take some fingerprints and they're out, right? And they'll take that as in, nothing happened. They would just let you out.
Oh, they let me go.
Yeah, exactly. They almost got the get out of jail free card
Right.
in that moment in time, and they'll just never think about it again. But time and time again, that has shown that it's not the case. It's always vital to get those records.
What are the consequences of lying to USCIS or Border Patrol?
The consequences can be severe. It really depends on what it is that you lied about.
They lie about the name versus they lie about their intent to enter, on why they're entering the country.
Yeah. So if you just give a false name or a different name, you're still going to get some consequences for lying to them, but it's not as extreme as if, for example, they try to come in and they present a false document saying they're a citizen. For example, if you lie to an officer and you say you're a citizen, technically under law, that's an automatic disqualification from ever being able to obtain immigration benefits from there.
Right.
And it doesn't even have to be that you were caught at the border. You can get stopped at some moment in time out here, and it's a, Border Patrol officer. You tell them you're a citizen, and automatically they'll disqualify you from ever being able to obtain some form of immigration relief.
And that's why I say it's always better to remain silent than to tell a lie. And that applies to criminal defense and these immigration situations. It's always better to just say nothing than to try to lie your way out of it.
Exactly.
Let's talk about something a little bit more fun. Trump's coming out with the gold card. What do you know about the gold card?
The gold card, as of right now, there's very little information that has come out about it. It is in relation to the EB5 visa, which is investor's visa. So you paid a certain amount. I believe the investor visa right now is about $800,000 to $1,050,000 to start that process. Mm-hmm. In regards to the gold one, well, the EB5 visa, you have to employ a certain amount of people. I believe it's 10. Mm-hmm. So you do have to create some form of job opportunity for U.S. citizen. From what we've been told and what we heard about that gold card, is just a matter of investing the $5 million and you're in. Mm-hmm. There is no jobs that need to be established or created from it. You just ultimately, in the simplest way, you buy yourself. You buy your way into the U.S.
So I've seen that 1,000 gold cards have been sold so far. Are those forms available yet on the USCIS website?
As of right now, no. I know they've been sold, but I think they have specific individuals who requested it with either immigration or government officials to request it.
Those are pre-sale tickets.
Exactly. That's a perfect way to put it. But as of right now, full forms for everybody or for the public to be able to start it, they haven't been released just yet.
I see.
A lot of the times, we get clients in the office, right? And we try to let them know that it's always important to get a criminal attorney and an immigration attorney. Sometimes they come in and they get a DUI and maybe they have DACA, right? And sometimes they don't know why it's so important to have an attorney that has both, that is able to help them out in both scenarios or be able to get both information from both sides, both the immigration and criminal side, to be able to best assist them. And what would you say would the ultimate benefit to having that?
So you need to, if you have a criminal case, it's very important to consult with an immigration attorney or hire an attorney who does both criminal defense and immigration work, because any criminal conviction or even a plea of no contest can result in immigration consequences. So before a person enters a plea, if they are an immigrant, they need to find out exactly what their options are. It might be better to take the case to trial and fight it out completely if there's going to be really adverse immigration consequences. And it's really interesting. Right now, there's a bill in the government to make a DUI a deportable offense. For the past over 10 years that I've done criminal defense, we've always been told, no, DUIs are not deportable. They're an immigration safe offense. Don't worry about a DUI. You're not going to get deported. But that may change. So moving forward, past DUIs might come back to haunt current immigrants, and their past convictions may come back and make them now deportable. So we will have to go back in time and try to vacate those past convictions. And the argument is that they didn't know what the consequences were. They were not properly advised that the laws may change. So we need to take another look at it. And if we were to have restarted the case today, if we knew then what we know now, how would we have handled it differently? But you need to talk to if you are an immigrant and you have a criminal case, it's really important to talk to an immigration attorney before you enter any plea. It was a little bit jumbled.
Thought that was good. Do you want to go a little bit deeper on that? On the 17?
Yeah, we could talk all about post-conviction relief.
Yeah. So for those who do have some, or maybe don't have an immigration status, maybe they have DACA, maybe they're here on a certain visa. If they are convicted of a specific of a crime, what would be post-conviction relief that they could obtain?
So there are all sorts of things that we can do when people have a past conviction. You can do a simple motion to dismiss, like a 1203.4, which is great for U.S. citizens if they want to apply for a job and they don't want that conviction showing up. But that may not fix things in the eyes of immigration. For an immigrant, there might be different relief available. There is a motion 1016.5, which means they weren't properly advised of the immigration consequence of their plea. Also, 1437.7, another improper advisement on the immigration consequence of their plea. If someone has a past conviction, they should talk to a criminal defense attorney who also does immigration to see if they can get that past conviction vacated and taken off their record. Okay. That was a lot of words. A lot of numbers.
A lot of words, numbers, but it's all good. It's all good information to know, because I know a lot of people, they get convicted of a crime and they're just lost. They're just not quite sure which way to tackle it or which one to contact first.
Yeah, and in many cases, the convictions are so old that the court doesn't even have records. This has gone up and down in the Supreme Court. If we don't have a record that the person was properly advised of the immigration consequence of their plea, the presumption is that they weren't. So sometimes with older cases, it's actually easier than with a case that's, say, 5 or 10 years old. If a case is 20 years old, those records are long gone. And it's actually not that big of a challenge to take that off an immigrant's record.
Okay. That's good to know. Let me see.
I don't know. Do you have more questions about that?
Good question I was going to ask is, what about somebody who's currently in a process for immigration and they maybe they get a DUI?
Okay.
Right. What would be, and this is similar to, hopefully we got this out to Simon Mata, right? He has that conviction.
Yeah.
At that moment in time, him having priors, he has priors, he has other cases, but he's still he just got a new one and he has an immigration process at the time.
Right.
Would you recommend him taking that case on first, or doing the clearing of the record, doing the...
Oh, yeah. So...
Or is that even possible while you have the case?
You can't. So like with 1203.4, there's 3 conditions. One is that you complete probation, paid all fines and fees, not facing any new charges.
Mm-hmm. Okay.
So I think that's for 1203.4. But with 1437, I think you can do it. I think you can raise that issue at any time for the priors, because it's a due process violation, right?
Okay.
So if their due process was violated, you can bring that up at appeal. You can bring it up 5 years later. It doesn't matter what's going on at the time. You can bring it up. Okay. So I think there's a difference there. The 1437 or the 1473, did I call it 37?
No, I think you said 73.
I think the 1473 is more powerful because of that, because it's a fundamental rights issue.
Yeah.
So relief under Penal Code 1473.7 is very powerful. And my take is that this can be raised at any time, even if a person is facing new charges or they're in the middle of an immigration process and they want to clean up their record. If a person has past convictions that might be getting in the way now, they should definitely file for that sort of relief if they were not properly advised on the immigration consequence of their plea.
Okay, I understand. For those who don't have status or are here with the visa, if they are to get one DUI, maybe it's their second, what is the best way to tackle that?
Well, I think you need to fight that DUI in the criminal court. And we might be able to make an additional argument that the person should be given an alternative plea because I think that person needs to fight it very hard in the criminal court. And a criminal defense attorney who understands immigration may be able to make an argument that the collateral consequences for an immigrant are greater than the consequences for a citizen. And based on that argument, you might be able to find an alternative plea to a DUI. Right now, there's a bill in the government making the consequence of a DUI very, very harsh. It can become a deportable offense. If that's the case, if an immigrant is facing DUI charges, they absolutely need to fight it. They need to consult with an immigration attorney or a criminal defense attorney who also does immigration.
Perfect.
During an immigration consultation, what questions do you ask?
Oh, the first one is, I guess my first one is the one I always start with is, have you started a process before? Has something been filed, or maybe you've been in front of an immigration judge? This is important to have. Depending on how that question is answered, we can get an idea, okay, this is the best possible route to take, or this is what you need assistance with. If they never filed anything, the following questions is, when did you come in? How did you come in? Do you have a criminal record? That's definitely the vital ones. If they already had a petition, or if I ask them if they started a process and they say yes, all right, do you have the documentation for that process? Do you know where it ended? Is it still in process? Sometimes we have people come in and they'll say, oh, I had this petition that started about 10 years ago, but I have no idea where it's at, or where it's, or if there's something left to do on it. And once we look into it, we can see, what, this person is able to do a full adjustment here. They don't have to do maybe consular processing abroad. Maybe everything can be done here in the U.S. based off that petition that they filed years ago, and they just completely forgot about it.
If two people get married, if there's a U.S. citizen who marries an immigrant, how long will it take that immigrant to get a green card?
It depends. I guess the main question is, do they have to do consular processing abroad, right? Or can they adjust in here? The law says that in order for you to be able to fix in here in the United States, you need one of two things: either a legal entry, whether it be a visitor visa, work visa, any one of those, or have a petition filed for you before April 21st, 2001. If you have one of those two, your spouse can petition you. You show that the petition was submitted before, or that you had the legal entry, and you file your residency application, work permit application, all in here in the United States. And you should be able to obtain that residency within 2 to 3 years. You'll get a work permit within 6 months, max, if that.
What is consular processing?
Consular processing abroad is the National Visa Center. It's for those who can't adjust inside the United States when they file the petition. So for those people, they don't have the legal entry, and they don't have a petition that was submitted for them before 2001, April 2001. Since they don't have that, the process now, it takes longer, because now they have to go for an interview to their country of origin, and that's where they obtain their residency. And before they go to that interview, they need a pardon. And that pardon is for the legal entry and having lived here illegally all that time. So now that pardon alone takes about 39 months to process.
Oh, wow.
That's something that those who are able to adjust in here don't even have to consider. That's not part of their wait times.
I see.
So if we take into account the pardon, the petition, and then having to go to your country of origin for that interview, you're looking at about a 4 to 5 year wait rather than the 2 to 3. It's almost an additional 2 to 3 years of wait time. But take that with a grain of salt, because immigration times do change. They change on a monthly basis. So we can take a look at the times today and be like, definitely, you'll get it done in 3 to 4. And then next month, immigration, maybe some policies changed, new things come into play, and now it's going to take longer.
I see.
It's just really hard to say, and it kind of sad to say, but we are in immigration's hands once we submit all these things, and we just have to wait to see what they say.
It seems like immigration laws are changing every day. Does that make it difficult?
It does, because you always have to be on top of it. For example, the bill that we were talking about in regards to DUIs, that can affect thousands of people, right? And if it comes into play, it changes all these cases that maybe are already in a process. Mm-hmm. Now we have to see how we can get this criminal record removed, because if it does become a deportable offense, Now a pardon needs to be put into place for these individuals. While before they did it, they
I
could have
see.
just continued on without it.
What is a waiver?
A waiver or a pardon, however you would like to say, is it's something that forgives you for your immigration history, right? So a lot of people, they come in illegally. They stay here. They might have a fake social that they use to work. That pardon is to forgive them for these acts, because under law, it is a crime to come in illegally. It's a crime to be here all this time illegally. But this pardon is made for you, so that way, or made for the people who want to fix and adjust, so that the way they're forgiven of these crimes. And if they have to go to consular processing abroad, they're not stuck out there for the 10 years that they're threatened with.
I see. What is a U visa?
A U visa is a visa designated specifically for those who have been a victim of a crime here in the United States. To be more specific, it does have to be a violent crime. So, for example, assault, attempt to homicide, maybe domestic violence is the big one. Right? These crimes fall specifically; they have to affect the individual. If it's just maybe somebody broke into your car, or maybe something was stolen from you, unfortunately, you don't qualify on it for those. But if it's a more severe crime, you qualify for a visa, and that's a pathway for you to adjust.
I see. How long does a U visa take?
A U visa, based off the times that immigration has right now, it's about a 7 to 8 year wait. But that's just due to the fact that there's so many people that apply. There's a vast majority of people who apply. The U.S. only accepts about 10,000 per year, and that's all the states. In the United States, incomplete, that they process these applications.
While a person is waiting for their U visa, can they get a work permit?
Yeah. So part of the U visa process is that you get not only the U visa, but you're able to apply for a work permit while the process is waiting. Because 7 to 8 years, it's a long wait time for a lot of people. So after about a 2 to 3 year wait, you'll be able to get a work permit, a social security number, and you'll be here in the United States with no issues up until that U visa is available for you.
Can a person with a U visa in process be deported?
That's a complicated question. It really depends. It's really based off their criminal record. We've definitely have instances when somebody has a U visa pending and they start committing a plethora of crimes.
Right.
If you have a big criminal history, immigration has the ability to put you in front of a judge and then take you out. And then you're outside of the United States while your U visa is still processing. Or they could even deny it based off that you might just be a liability for the state, or you're a danger to society. Those are the times where I've seen people do get deported, even with the U visa still pending.
What is VAWA?
VAWA is very similar to the U visa. It's more designated for those who have been a victim of domestic violence. So this is a little bit more specific. Like I said, it's mainly for those who have been a victim of domestic violence in comparison to just a victim of any violent crime.
I see.
And it does help because it does process a lot faster than a U visa. It's a whole lot faster. But we do need to prove a lot more in regards to the relationship. So you do have to be married to the individual. You do have to have some form of proof of the damages that were done. In comparison to a U visa, you could be a victim of a crime and that individual can be nothing to you. It could just be a stranger out in the street.
Right.
And you get a police report and you qualify for that. While with VAWA, you do have to show the relationship between you and the person who inflicted these things to you.
So VAWA is the Violence Against Women's Act, but could it be violence against a man?
Yeah. There is no gender specific. If you're a victim of domestic violence, you fall under VAWA. The titles might be a little bit confusing, but any individual, male or female, can qualify for it.
What if two people are in a dating relationship and the U.S. citizen gets in a fight with the non-citizen partner? If they're just in a dating relationship, would they qualify for VAWA?
They still would. They still would qualify for VAWA if we can show that the relationship was there, right? Maybe we have instances where people live together, been living together for years. They just never went took it upon themselves to get married,
Right.
right? But that relationship alone proves that they were living together, or it shows that they really were in a relationship, maybe just not officially on a piece of paper.
Right. Maybe they have children together.
Exactly. They have children together, and what solidifies a relationship more than a child?
Right.
So even if they're not married, if they live together, they have children together, even if they consider it dating at that time, they can still qualify for VAWA.
I see. What if there is a U.S. citizen child who commits abuse of their non-citizen parent? Could that parent qualify for VAWA?
They wouldn't qualify for VAWA, but they would qualify for U visa.
I see.
Or actually,
No, it's
I think
VAWA.
They
Okay.
do qualify for VAWA. You're
Let's
right.
hit it
right?
again. Let's
Yeah,
hit it
yeah.
again.
So
Let me ask it again.
yeah.
What if there is a U.S. citizen child who abuses their immigrant parent? Could that parent qualify for VAWA?
Yes. So if the U.S. citizen child does take advantage of the mom, which we have seen, sometimes these kids grow up and they start abusing the parent. In that situation, and although some parents might not want to get some form of benefit due to this, they do qualify. They'll qualify for VAWA. They'll be able to get benefits from there. And, they'll just need to show that the child is theirs, that they are the parents of these childs. Just by proving that and showing the damages that have been inflicted upon them, they'll qualify for VAWA. And this is where a lot of people might not take the necessary steps, right? They might not call the police department on their child, or they might not even ask for medical assistance if something happens.
Right.
And it's important to get that. It's important to file the police report, go to get medical attention, because all of this is going to come into play with that VAWA application or U visa application.
So if a person has been abused and they want to apply for VAWA, does it have to be physical abuse, or could it be like emotional or financial abuse?
It could be emotional, it could be psychological or financial. Sometimes some partners live together and the other one tries to hold the immigration side over their heads, saying that, well, if you don't do this, or if you happen to leave me, I'm going to report you to immigration. I'm going to, call ICE on you. All of this affects, the immigrant a lot, and they qualify for VAWA based off that. If we can prove that they've been threatening them with immigration consequences or threatening them with some form of violence, they'll qualify for it.
What if an undocumented immigrant is working for an employer and the employer starts telling them, listen, you need to work unpaid overtime, otherwise I'm going to report you to ICE? Does the immigrant have any recourse there?
Even there, they'll qualify for it. They'll qualify for U visa, actually. For U visa, U visa has a list of crimes that qualify them for that specific visa. Mm-hmm. And that happens to be one of them. The list is quite large. And even if a police report isn't filed, one can still file for that just with the necessary proof to show it. And this is where it's important to have, an attorney who's there to help you.
Yeah. So if the boss is texting their undocumented employee, like, I'm going to call ICE on you if you're late one more time. I'm going to call ICE on you if you try to report me to the labor board. Would they be able to get benefits if that happens and get some documentation?
Yeah. All of that will be used. All of that will be used on the U visa application. They'll get their work permit. They'll get a social security number. And ultimately, they'll just be in a waiting list to be able to get their residency. So it's important for people to know that when they're victims of these crimes, they can get benefits from it. They
Right.
just need to make sure to seek the right counsel who's going to be able to lead them and take the right path.
I think we kind of beat the shit out of that one. That was good. In immigration, who can sponsor another person?
For immigration, the one who can sponsor an individual is a spouse, a parent, a child, a step-parent, or stepchild can't even petition you. When it comes to step-parents or step-children, there's a little bit more criteria that they have to meet. Maybe things have to be filed before they reach a certain age, or be by a certain time when they marry the child's mother, if it's a step-parent. All these are taken into effect, but for the vast majority, it's always a spouse, a parent, or a child.
In order to sponsor someone, does a person need to be a U.S. citizen, or can they be a green card holder?
They could be either or. If they're a citizen, things will be processed quicker. They'll definitely be at the top of the line. In comparison to somebody who's a permanent resident, things will take a lot longer, and they won't get things as quickly as a U.S. citizen does. But a person can still file the petition while they're a resident. And then if they truly want to speed things up, they can go become a citizen while the petition is still pending. And then we just let immigration know, let USCIS know that they're a citizen now, and they'll move them from the track that handles resident petitions to the one that's U.S. citizen petitioning their family members.
How long does it take for a green card holder to become a citizen?
It takes, for a green card holder to become a citizen, and we're talking they have no criminal record, it's clean as a whistle, give or take about 3 to 6 months. And according right now to USCIS, if you go, you take the test in a USCIS service center, if you pass the test, they might do the oath ceremony that same day. So it's possible that same day after you pass the test, you'll become a citizen. They'll give you your certificate day of.
How long does someone have to be a green card holder before they can apply for U.S. citizenship?
For somebody who's a resident, technically they have to be a resident for about 3 years. For about 3 years, and then they can apply for citizenship after that. If they want specific requirements or specific adjustments to the test, maybe they want to take it in Spanish. If they want to take it in Spanish in their native language, they do have to meet specific criteria.
Like they need to be over 65 years old, or what do you mean?
Exactly. They have to be over 65 and be a permanent resident for about 20 years. It could be, if you're over 65, maybe you have to be a resident 10 years. Yeah, I can't remember the exact amount of years or how old you have to be, but to take the test in your native language, these are specific requirements you have to meet.
I see. What is military parole in place?
Military parole in place is a benefit that family members of military personnel are able to obtain. It's specifically more for parents and spouses who are able to obtain it, but it is a really good benefit to get. We like to say that it's very similar to a DACA, right? Whether, let's say, two parents have a child who just happen to join the military. It doesn't even have to be a Marines, Army. They can be reserves, and they'll qualify for this. They'll be able to petition this military parole in place for their parents, and their parents will be able to obtain a work permit and a social security number while they wait for their child maybe to turn 21. And then that same child will be able to petition them. In the grand scheme of things, the good thing that it does, in the simplest way, is that it'll turn that parent's illegal entry into a legal entry. And that will allow them to fix in the United States without having to go and do consular processing abroad in their country of origin. And they won't even need that pardon that's required for those who do have to do that route.
Let's hit this one from a different angle. If there's an 18-year-old and their parents are completely undocumented, is there anything they can do?
Yes. If that child wants to join the military, that's a benefit that they could obtain. I know a lot of families, they don't want their kids to join the military, which is understandable. But if their child does join the military, they're able to give their parents military parole in place. And this military parole in place, in the simplest way that I can put it, is it's very similar to DACA. They'll be able to get a work permit and a social security number after this process. And while they wait for their son to turn 21, they'll be here with the work permit. Once their son turns 21, they'll be able to petition them.
Son or daughter.
Son or daughter, exactly. They'll be able to petition them, give them military parole in place, and then they turn 21, and then they can do the adjustment of status here. Because one of the benefits of military parole in place is, in the simplest way that I can put it, is that it'll turn that illegal entry into a legal entry.
I see. So they won't have to do consular processing. They won't have to step out.
Exactly. They'll be able to do all the adjustment of status in the United States without ever needing to step out. And they won't even need a pardon after that.
If someone is 21 years old or older and their parents are completely undocumented, can they do anything to help their parents out?
They can definitely petition them. A son or daughter who's 21 or older can definitely petition their parents. But where that petition is going to go really depends on the parents' immigration history, whether they're qualified to adjust inside the United States or if they have to go out. So, for example, if they came in illegally and they've never had a prior petition submitted for them, they would have to do consular processing abroad, and they would need a pardon before they go do consular processing. The dilemma occurs with that pardon. And it's that although your child can definitely petition you to start the process, they don't qualify you for that pardon. And
I see.
Yeah, and then that's where a lot of people get stuck on. They see that their child is a U.S. citizen. They turn 21. They can definitely petition them. But then they get stuck at the pardon part. And that's because the only people who qualify you for that pardon is your parents or your spouse. So your parents or spouse has to be a resident or a citizen to be able to obtain this pardon. If you have DACA and you commit any type of crime, should they seek legal advice?
Yeah.
Even on the simplest ones, it could be as simple as, what's a simple crime? Drunk in public?
Or reckless driving.
Reckless driving?
Or what's like a low-level offense? Drunk in public or disturbing the peace?
Disturbing the peace?
Yeah.
Yeah, right. Okay, I got you. Now, for example, for those who have DACA, right? I know a lot of people were able to get DACA. They have their work permit. They're perfectly fine. Maybe they go out and they commit a crime, for example, drunk in public or reckless driving. Do you recommend for them to seek legal advice?
Yeah, of course. So DACA protections are some of the most fragile protections in our entire immigration system. If a person has DACA, it is critical that they talk to an immigration attorney before they enter any plea. There may be alternatives to entering a plea of guilty or no contest to these charges, and we don't know how a conviction for something low like disturbing the peace may come back in the future and destroy a person's DACA. So it's really important that they talk to an immigration attorney in addition to their criminal defense attorney to find out all of their options.